Hi everyone, this is Ashish here and welcome back once again to this video on money recovery, and we are talking about cheque bounce. Now, in the previous video, we saw what are the procedures and timelines to be followed in the case if a cheque is being dishonored. Now, we also suggested that you can send a legal notice to the person who issued the cheque and ask him or her to pay up the amount within the next 15 days. But if the person still does not pay up within the next 15 days, we recommended that you have a right to file a complaint against the issuer before the magistrate court as under section 138 of the Negotiable Instrument Act. Now, the most important thing to know that in any cheque bounce case, timelines are very crucial. So, if you missed to file this complaint before the magistrate court within the 30 days, what is it that you can do? So, keep watching this video to know what steps you can take. Now, even if you miss the deadline of 30 days, you can still approach the magistrate court and request them to make an exception for the delay if you have a valid reason to justify. Now, note that the reason that you provide the magistrate court should be convincing enough for the court to accept your petition and allow the case to be filed. So do let us know in the comments down below what you think is a valid reason for the delay. Now, let's say you are from Chennai and you hold a bank account in Chennai, and the person who gave you the cheque is from Mumbai and they hold a bank account in Mumbai. Now, in this scenario, which of the two magistrate courts should you approach? Well, ideally, you can approach both of them. You have two options. You can file the case in the court under whose jurisdiction the branch of the bank where you maintain the account is situated, or you can file the case in the court under whose jurisdiction the branch of the bank where the drawer of the cheque maintains an account. Assuming that the magistrate court accepts your request and allows you to successfully file the case now, so what happens in this scenario? How long does it take to get an order? What kind of order can you expect? So let's go ahead and look at all of them one by one. Now, once your case is successfully filed, the magistrate court will send a notice to the issuer of the cheque to come and appear in front of the court. On the appointed date, the issuer of the cheque will either plead guilty or does not plead guilty. Assuming that he does not plead guilty, the case then moves on to the trial. During the trial, both the parties are supposed to provide evidence in favor of their respective claims, and the court will then take a note of all the evidence that is produced to determine whether an offence of a cheque bounce has been committed or not. Like I mentioned in the previous video, the original cheque that you hold and the cheque return memo issued by the bank will act as important evidence in your favor to prove that the cheque bounce offence has been committed. The courts are expected to try and complete the proceedings of the trial within 6 months from the date of filing the complaint, but in certain exceptional scenarios, it may go beyond 6 months as well. Once the trial is over and the evidence is produced, the court will hear the arguments from both the advocates of both the parties, post which the court will then pass an order. In a cheque bounce case, if the issuer is found guilty, the court can pass an order for imprisonment up to 2 years or can impose a fine which may extend to twice the amount of the cheque. I hope you are more confident now than before on how to recover money in a cheque bounce scenario. Now, very similarly, you might have paid for a product or a service as a consumer and your money might be stuck there. So, watch out for the space, because in the next video, we will be talking about all those consumer rights you must be aware of for recovering of money. Now, if you found this video to be helpful, please leave a thumbs up and subscribe to the channel for more content on money recovery.